Hi, my name is Robert Shelley with Chelle Law, and my law firm assists physicians with employment contract issues. Today, I'm going to talk about what you should know before you sign your first physician employment contract. So, this is a pretty broad topic, but we're going to hit kind of the main areas, things to think about prior to signing your first employment agreement. So, first, figuring out whether the compensation that you're being offered is fair market value. So there's a couple of, good ways of going about trying to find that. Well, one, the MGMA, the Medical Group Management Association, collects annual salary data from across the country. If you can get access to that, they have a lot of good information about total compensation, average net collections, average RVUs generated by specialty. It's hard to get that info sometimes. I mean, if you Google around, you might be able to find some of the compensation data that's a couple of years old. Or you can talk to someone who has access to the data, at least like for our firm, we have access to the data. So, we can tell the physician exactly what the numbers say. Now, that's certainly not the be all end all. There are other services out there that offer something similar, but I also think it's limited in the fact that some of the specialties have a very small sample size. In addition, that just total compensation should not be the determining factor when somebody's looking for a job. All right, so that's compensation. Now, another way of thinking about it would be if you have classmates in your training program. You need to ask them what they're receiving. Now, it's going to vary based upon geography and then setting. So, are they going into a hospital network? Are they going into some kind of federal facility? Are they going into, private practice in some way? So, it's good to speak to people that you train with to kind of see what they're being offered. And then mentors are another good place. So, if someone's already out, and maybe they've been a teacher for you or a mentor in some way, just ask them if they're willing to talk about the type of compensation that they're receiving. Next would be how to terminate the agreement. It's something you really need to think about. There are 4 ways to terminate a contract. If the initial term ends, so let's say you have a 2-year contract and there's no language that states it automatically renews, then it just ends. Contract terminates. You can terminate a contract by mutual agreement. You can also terminate a contract with cause. So if one of the parties breaches the contract, either party can terminate the contract if the other party doesn't fix the breach. It's called a cure. And then lastly, and this is what I want to hit on, is without cause termination. Every contract you sign has to have without cause termination in it. Now, there are very limited circumstances where no without cause termination would be okay. If you're a J1, that's one that it actually would probably benefit you not to have that in there. But in almost any other scenario, without cause termination simply means you can terminate the contract at any point for any reason with a certain amount of notice to the other party. Now, contracts that don't have without cause termination, meaning you have to work out whatever the initial term is. There's no way of terminating the contract for any reason. They would have to breach the contract if you wanted to get out of it. The reason why you need that is, let's say you, start with a job and the volume, you're paid on productivity and the volume's not there. It's not your fault. Or maybe they brought you in telling you it was going to be one way and the call is just excessive. Or maybe it's just a terrible personality fit. For whatever reason it is that you're not happy in that job, you need the ability to get out of it if you want. So you have to have without cause termination in the contract. It should be somewhere between 60 to 90 days is standard for physicians. All right, next, the non-compete. So a non-compete simply says the physician can't work after the contract terminates for a period of time within a specific area. So as an example, most non-competes are 1 year, sometimes all the way up to 2. And then a reasonable kind of mileage would be 10 to 15 miles from your primary practice location. Now, many times the employer will try to tag on multiple locations. So maybe if you worked in 3 outpatient clinics and a hospital or something, they try to attach it to all 4 of those. Or maybe the employer has tons of facilities in the area. You've only worked at one of them. They might try to attach it to all of the facilities they own. That's not fair either. So you want to try to get it to 1 year, 10 to 15 miles from maybe at most 2 locations. Anything beyond that would be considered unreasonable. Now, there are a few states where it's completely unenforceable to have a non-compete, but for the most part, the vast majority of states allow non-competes for physicians. Lastly, malpractice insurance. So the employer should almost always pay for your underlying annual premium. So how much they have to pay each year to insure you. Now, depending upon the policy, either if it's a claims-made policy or an occurrence-based policy, it's going to determine if you have to pay what's called tail insurance. So if it's a claims-made policy, tail insurance is necessary. And a good rule of thumb is tail insurance costs about twice what your annual premium is. So some specialties, it can be very expensive. OBGYN, some of the higher level surgical specialties, they could have tails that are $50,000 to $100,000. Obviously, you want to avoid having to pay for that. So making certain that there's some kind of either a fair split between the employee and employer, or having the employer pay the complete cost of the tail. Or there's also insurance called occurrence-based coverage. And in that scenario, tail is not needed at all. It's about 1/3 more expensive than claims-made. But in that scenario, you won't have to pay for tail insurance. Now, there are obviously probably dozens of other things you need to think about. I would say in my mind, those are probably the 4 most important. But you have like benefits, bonus structure, length of the contract, some of the other restrictive covenants of the non-solicitation agreement, non-disparagement, confidentiality, your hours worked, the call. I mean, there's a ton of things you need to think about. So I would suggest reaching out to somebody who has experience reviewing contracts. I mean, when you're signing a contract that could be literally worth $1 million, it would be pretty, at least in my opinion, pretty foolish not to get it looked at by someone who knows what they're doing. If you have any questions, you can call my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. And I appreciate you watching the video. Thanks.